Albert Cork was 39 with a wife and child and had epilepsy. In 1950, treatment was still quite rudimentary and he could have a seizure at any time. His doctor had emphatically warned him that he should not work at heights where there was the risk of a fall. Despite this, he took a job as a painter, and on this particular day he was required to ascend a 6-metre scaffold in order to paint the inside roof of a factory. He had not told his employer about his epilepsy. According to statute, at any height above 2 metres, the working platform had to be supplied with guardrails and tow boards to prevent people from falling. The painting platform in this case did not have tow boards or guardrails. While working, Mr. Cork had a seizure and fell. He died, and his widow brought a negligence action against his employer. The breach of duty was quite clear, and the key question at trial was whether that breach had caused the death. The usual method for considering causation is called the but-for test. We ask whether the injury would have occurred but for the breach. In this case, however, it was possible to say that death would not have occurred but for the absence of the safety features on the platform. But it was also possible to say that the death would not have occurred but for Mr. Cork's poor decision to work at heights after having been instructed not to by his doctor. So which was the cause of the harm? Common sense prevailed and the court said both. Lord Denning said, if you can say that the damage would not have happened but for a particular fault, then that fault is in fact a cause of the damage. But if you can say that the damage would have occurred just the same, fault or no fault, then the fault is not a cause of the damage. It often happens that each of the parties at fault can truly say to the other, but for your fault, it would not have happened. In such a case, both faults are in fact causes of the damage. From this case, we learn that in negligence law, the but-for test has limitations, and it is sometimes possible to say that there was more than one cause of an injury.